was concluding my submissions by addressing you on the what I'd understood at least to be the way that the claimants now cast their claim in terms of heads of loss. Before I continue with that, my lord, you asked me about the transcript in reference to the Ponzi not being within the scope of my duty of care. I've shown you what was in the judgment and the skeletons.
I think you gave me a reference.
And I did, and I've got one more for the court.
Okay.
It's page 166, lines 16 to 23. And just on the topic of Ponzi schemes, my lord and I had an exchange about whether it was a necessary part of a Ponzi scheme for there to be misappropriations.
Yeah.
I think it's probably right that it's not a necessary part, but it would be difficult to envisage one where there weren't, because otherwise why bother?
It is conventionally done in order to enrich the participants.
I'm certainly not aware of a Ponzi scheme where there hasn't been alleged to have been misappropriated.
I think that was certainly the case in the case of Mr. Ponzi's original Ponzi scheme.
Indeed, and in the case of Mr. Madoff's notorious Ponzi scheme and Mr. Stanford's Ponzi scheme.
Alan, I think he was called.
I'm sorry, Mr. Allen. I'd made the point then, we were looking at the sales pitch.
Yes.
I made the point on no loss, they've got full consideration. We addressed the topics of the money comes into the SPV solicitor's account. As soon as it's released into the solicitor's client account from escrow, it belongs beneficially to the company. Anything that happens after that scintilla in time, payments out to sales agents or whatever, by way of legitimate expenditure, is a matter for the company. And is a use to which the money is put, and that is not alleged to be within the scope of my client's duty of care. And my lords, we can see or put the matter differently. The claimant's case is that Mr. Woodhouse caused these companies to make these legitimate payments out in the knowledge that the schemes were unviable. That's their case. I've shown you the document.
Yes.
And that's why, in the long term or medium term, these companies did not ultimately turn a profit that would eclipse the initial expenditure. One does have to stand back and look at the economic reality of what's going on. In a legitimate business, you invest, you earn out, you profit. The reason why these companies did not ultimately make a long-term profit and eclipse the initial expenditure has nothing to do with the CIS, it's because of the fraud. And they say that Mr. Woodhouse knew that that was what was going on when these payments out are made. How can it possibly be right, and put it rhetorically, to then say that solicitors who've advised on the CIS status of the schemes are responsible for that? It would be perverse. I was then turning to this question of an immediate or automatically incurred liability.
Section 26
Section
point.
26. And my lord, we had exchanges about this before. It is a fundamental part of the case now advanced on appeal. It featured less at first instance. The expressions that one now sees in the replacement skeleton of immediately, necessarily and automatically incurred expenditure and of other expenditure, which one sees in the core bundle at pages 55 and 56, those labels were not used before the judge below. But
immediately incurred expenditure is the service charge commissions and the legal fees.
The sales agent commission, yes.
Sorry, the sales agents commissions and the legal fees. What we're talking about is whether the Section 26 liability attaches immediately.
I agree. And what the claimants are positing is a comparison between two things. And that comparison
on day one, on day one,
or is it day zero, whichever one. And the comparison involves, as its premise, what's described as an immediate liability under Section 26.
Yes.
And that's
to cancel the positive effect of the receipt of the investment.
Now, that is a false premise. Even if it were right, it gives rise to no loss. We've dealt with that. But it's a false premise, and I take the point about a contingent liability. But can we just look, please, at the sections of the statute? It's just important that the court approaches this on the correct basis, and it's in appeal authorities tab 1. I'll just make my submissions on it. You're familiar with section 26, which is the section my learned friend took you to, in the reference to an entitlement. And it's section 28, page 10 of the bundle. And the point about whether it's automatic or immediately incurred, properly analysed, properly understood. And I draw your Lordship's attention to two aspects of the statute. 28.3 provides that if the court is satisfied that it is just and equitable in the circumstances of the case, it may allow the agreement to be enforced, i.e. against the investor, and it may allow money and property paid or transferred under the agreement to be retained. So there is a power there, and the matter is effectively subject to the court's evaluative discretion on a just and equitable basis. There is no automatic or immediate liability.
I think Mr. Pickering said it was a default position.
And I'll turn to that next.
And I think you could say that even if the court has a discretion in particular cases to allow it to be enforced, one can see that it might be a default position, that unless the court is persuaded it's one of those exceptional cases. And if you look at subsections 5 and 6, it's really where somebody has innocently got themselves fallen foul of a statute, which is, we're not in that territory.
No, not on the claimants case, I agree. But if one looks at subsection 7,
subsection 7 makes it clear there is an election for the investor to enforce
and
it.
it's an election into their statutory remedies.
So election not to perform. Yes.
Exactly. If the person against whom the agreement is enforced elects not to perform, and as a result recovers money paid.
Or as a result.
Or no, quite right. But there's the requirement there then to provide counter restitution. The submission I make on the basis of these two provisions is this: it is not automatic. It doesn't give rise to an immediate balance sheet liability for the full amount.
I mean, they would cover a situation where you hadn't paid the investment funds already, and you were called upon to do so, and you elect not to because of the CIS non-compliance. It actually isn't directly referring to an election bit, is it?
I think that's probably fair, my lord.
Looking at it again.
It is expressly referring to an election away from enforcing the contract, which they would be entitled to do.
In practical terms, coming back to the example I was trying to put forward yesterday, it so happens we have non-compliance with CIS in this case, where there is an underlying fraud, Ponzi scheme, but you could have an unauthorised person running a CIS, and it's non-compliant with the 2000 Act, but it's a scheme which is doing very well, and investors are very content to take the 10% and so on. It isn't a Ponzi scheme, for example. So that would be consistent with it being a remedy, right, but something you can either choose to rely upon or not.
Absolutely.
And indeed, section 20.
Otherwise, the effect would be, otherwise the effect would be that the money is returnable, whether you want it back or not.
Agreed.
Sorry.
I was going to say section 28.9 is supportive of that. Section 29 is a provision designed to avoid the argument that because you're in breach of statute, it's void ab initio for both parties.
Exactly.
And section 28.9 says, no, it's not. See section 26. The investor, it's not enforceable against the investor, and he has a right to recover. But it's designed to enable the transaction to continue if that's what the investor wants.
And here one does see the language of election, and it's an election in favour of performing election in favour of not performing the agreement, which I
Sorry,
appreciate.
that's 28.7.
I'm sorry, 28.7.
Indeed, if it's not, the idea it's void ab initio would be inconsistent with 26 and the unenforceable provision.
Exactly.
Against one person, my lord said.
I agree.
I mean, if it's not void ab initio, it's void of all.
One way.
But that implies someone choosing to treat.
Exactly.
Yes. But if you didn't have that, if you just said you can't sell an investment unless you're authorised, then it would be in breach of statute and it would be illegal, and it would be illegal for both parties, and the investor wouldn't be able to take the benefit of it even if they wanted to.
That's right, Manny. So there is an election. The election, the language of section 28.7a, I put it no higher than this, would tend to suggest that the election has to be into your statutory rights, because you're electing not to perform and therefore to exercise your FISMA entitlement to the return of your money and possibly compensation. So I would suggest that insofar as a default position matters, even a default position doesn't give rise to an automatic liability you have to exercise. But the language of the statute on its face would rather suggest that the default position is the other way. And certainly on any view the court can interfere. That's the submission I make. It's not an automatic or immediately incurred liability. And we said in our skeleton, at the very most, it's some contingent liability that might be exercised in the future. That's not the way the claimants frame the case, which is an automatic and immediate liability for the full amount straight away. And when you take that away, their starting point is removed from under them. And this is what happens, again, not a criticism of anyone, they're absolutely straining every sinew to make this work, as is their job. But when you try and move your case into a different direction to fix a problem over here, you end up with a problem over there. And that's the tell of an analytically flawed claim. And the last point on this, and I've made this point already, but I'll repeat it in this context. At most, that section 26 remedy is an extra remedy available to the investor, which adds nothing to the company's burden because of the existing contractual claims or the existing tortious claims, which as a matter of principle cannot be for any less.
Yes, you've made that point.
Then I turn to this, what is described as other expenditure. This is referred to in the replacement skeleton at paragraph 30. Now, this is a very vague expression that appears to be intended to refer to any expenditure by these companies, legitimate, bona fide, market arm's length expenditure that comes at some later point on anything. Firstly, no pleaded claim at all. Secondly, we do not understand how it can possibly be said on any analytical basis that the solicitors who advise on the CIS status of the schemes are responsible for expenditure in the ordinary course of business on things that even the claimants even now aren't able to particularize. It's not an expression one saw in the grounds of appeal, the other expenditure. It comes in the skeleton served on the day of the PTA hearing. It is not at all clear what we are said to be responsible for, nor how. What it does appear to be is an attempt to save the vast majority of the financial value of the claim in circumstances where the immediately incurred expenditure is said to amount to about 12.5% or thereabouts, which means that the vast majority of the case is not supported. And so they identify this claim in respect of other expenditure. But this really is a fortiori to the immediately incurred expenditure, which doesn't work anyway. It really is asking us to underwrite the success of the business. And there is no duty of care in respect of this at all. And this is yet further expenditure that Mr. Woodhouse is deciding should be paid to, I don't know, construction companies or whoever, in the knowledge that the schemes are unviable. Second, my lords, the way it's expressed in the replacement skeleton, and this is a point again, I'm just drawing the strands together, paragraph 30, this new claim suffers from the problem I identified earlier in that it is premised on another false premise. At paragraph 30 it said the schemes were always intended to make a profit. I've explained why that's a false premise. The claimants' case themselves is that these schemes could and would never have made a profit. So the starting point is false for that reason also. Doomed from the start, and Mr. Woodhouse knew this. That's their case. Thirdly, no loss, because we're talking about legitimate expenditure, full value received. And fourth, all of the points, the prior points I've just made about immediately incurred expenditure also apply here, mutatis mutandis. Including that the starting point of an immediate liability to pay under section 26, which you hold against it, is a flawed starting point with a no loss analysis. The last head of loss that's now identified is the claim for compensation under section 26(2)(b).
Yes.
First point on this, and this is actually quite an important point, is this was dealt with by way of case management decision by the judge.
Is it a case management decision? I was thinking about this. Isn't it a construction of pleading?
Well, if my lords are of the view that it wasn't pleaded, then it's a case management decision.
Oh, I see. Yes.
If you're of the view it was always pleaded and the judge just simply got that wrong, then that's different. But if,
Mr. O'Doherty said that the pleading out in APOC 6 of this was simply clarifying what was always there. So we have to decide if it was always there or not, because if it was always there, then you have to deal with it.
yeah, I accept that. Yeah.
He also did it on the evidence.
Well, he also did it on the basis of the absence of evidence. Let's look at what the judge.
But you don't need to put evidence
No,
in on
I
answer to a strikeout.
I think the way the judge dealt with it was there's no pleading. You've also not put evidence in, and therefore, had I had one or the other, maybe I would have gone down that route. The judgment, so we can see exactly how the judge dealt with it. It's in the judgment, which is in the core bundle, tab 6. There are plenty of points on the substance, my lords, as well. And
You have about 12 minutes.
I will conclude. It's judgment and tab 6 core bundle, page 80, paragraph 65.
Yes.
However, I wish to show no evidence that any investor sought compensation, and this was not a matter which was pleaded. So I don't think there's any dispute that the judge was shown no evidence. So that's the correct statement by the judge. Not a matter which was pleaded in spite of 5 attempts by the claimants. So if the judge was right about that, then his decision not to take the submission into account, the raising of this by way of oral responsive submissions, because it wasn't in the skeleton argument either, that becomes a case management.
Yes, I see. I see the way you put it. Thank you.
Now, as to what's pleaded,
In the skeleton which arrived on the day of the hearing.
no, the skeleton which arrived on the day of the hearing was for the PTA hearing.
Oh, sorry, beg pardon, forget
For
that.
Lord Justice
The
Stingray.
skeletons for the hearing before Mr. Justice Sheldon arrived about 5 days before.
Yes,
the
my
hearing.
lord, and there's no reference to FISMA 26 compensation. So again, it's difficult to look at this pleading exhaustively, and it's a substantial document. But I've shown you the schedule. There's no reference to compensation there, or any equivalent reference. I've shown you paragraph 173, which identifies the losses. And so, my lord, and when we're back to yesterday morning, my Lord Justice Holgate said I think it was 177 and
177 241. It's engraved on my memory.
and mine too now, my lord. Those paragraphs say what they say. I'm not going to read them out or misrepresent them. They say what they say. For such losses that arise by operation of section 26. Then it's the point that arose in argument yesterday. Well, what does that mean? What is alleged through that? And to answer that question, you turn in the pleading to page 159, paragraph 62.
Yes.
And it's set out there. And it's the same language. By operation of section 26, the agreements became unenforceable and the investors became entitled to recover their investments from the assets of the SPVs into which they invested. No reference to compensation there or anywhere else at all in this pleading. And my lord, if there were any doubt, you do then go in my submission to paragraph 173, page 222, which lists out the quantum of the loss claim. We've looked at it before. And at 174, it says, further particulars are set out in Schedule 3, which we've looked at. So if you had any residual concern, you look at what they claim, you look at the number, and then if you want to know how that's made up, you look at the schedule, which is at page 273. And it is absolutely conclusive. There is no claim for compensation.
Well, that's true, but in 177, it starts with the word further and says we'll claim indemnities. Mr. Pickering said, we all know how liquidations work. You don't actually know what the liabilities are until the proofs have been adjudicated, and you don't bother to do that until you've got any assets to distribute. So it does look as if that's intended.
Well,
Add something to the quantified losses in 173.
in my submission, the judge was right and certainly entitled to conclude that there was no pleaded claim for section 26(2)(b) compensation.
Okay, we have that point. Suppose it were pleaded. What's the answer?
And let me pause there. If I'm right about that, the judge's decision not to go further on the point is, in my submission, a case management decision.
You've said that. Yeah.
And that I'm sorry, should not be. There's no error of law in the approach he then took. No error of discretion. Now, what's the answer on the substance? It's a number of the points, in fact, that I've already made. First, our alleged conduct did not increase the burden that the claimants face. Why? Because what section 26(2)(b) is referring to is a compensatory payment to an investor for the loss of use of their money, an actual loss per the Whiteley decision.
You show us what Mr. Justice David Richards said, because I think it's the only authority we've been cited on 26(2)(b).
Let me find it now. Forgive me.
Tab 7.
Thank you. It's tab 7, page 123,
Thank you.
and it's paragraph 29. He says, in my view, that must be a loss in order to be recoverable, in brackets, in fact sustained by him rather than a notional loss.
Thank you.
And one finds the language, it's the language of the statute in my submission, it's in and of itself makes that clear. It's compensation, 26(2)(b) says compensation for any loss sustained by him as a result of having parted with it. The court, in my submission, is well familiar with quantifying that. And my lord, that is never going to be greater than the equivalent measure in tort on the deceit claim. It can't be. If you can prove an actual loss, you would be entitled from loss of use of the money. You would be entitled to recover that on your deceit claim, at least to the same level of quantum. And that is a matter of principle. And my lord, I was addressing you briefly on the authorities earlier, and my lord was asking me about the extent to which semper remain good law because there have been subsequent decisions. I mentioned a couple of cases. I've pinned down the references. So semper metals starts the debate on compound interest at common law. The latest word on the subject is the Privy Council decision in Sagicor, UK 2022 UK PC 4. And the point made by the Privy Council is you've still got to plead and prove. It's available in principle at common law, compound interest. You've just got to plead and prove it. It's exactly the same in 26.2b. You're going to have to prove an actual loss. If you can prove it in one, it will be available in the other. There's no material distinction so far as the quantum is concerned. There is no loss that you can't recover. We're talking about loss of use of the money. That will be available in deceit in at least the same way, if not more generous in deceit.
Yes.
My lords, I also mentioned a decision of this court on the topic. It's Granville. Let me give you the reference, if I may. 2023 EWCA Civ 980. That considers the jurisdiction of the court to award compound interest in equity as opposed to common law. And it confirms it's available where it is the sort of fraud where the money has been taken from you and retained by the alleged fraudster, and where the fraudster is in the position akin to a fiduciary. Now that will be the position in the rescission claim, which gives rise to a constructive trust over the monies, and then and the compound interest follows. So the measure of this sort of compensatory element is never going to be less in the deceit claim than it might be on a section 26.2b claim, of its very nature, juridically. And the same point applies to the contractual entitlements. I've explained what they come to. Yeah.
Well, that requires one to assume that no investor could ever have done better than 10% elsewhere.
End the buyback. End the buyback. You've got to do better than 20%.
Yes.
It's not alleged that that is the case.
Okay.
You're comparing a claim by the investor for deceit with a claim by the investor for Section 26 relief. I appreciate what the claimants plead in this case about the behaviour of Mr. Woodhouse and others. But suppose, does it matter that the investors may not actually be able to establish their claim in deceit? I mean, we're working on the basis that they can, but whereas the Section 26 is just a slam dunk, isn't it? You can have it as long as they weren't authorised.
Well, my lord, I'm working on the basis, I understand entirely the direction of the question. We're working on the basis of what the claimants themselves allege.
Yes, I appreciate that, but they're claiming an indemnity against a claim by somebody else. And you're inviting us to say, well, the claim by somebody else, which we've never seen formulated in deceit, which they never have formulated, is bound to succeed and bound to be better than this indemnity. And I'm just wondering.
And I understand, but I make that submission on the basis of the aspects of the claimant's own case that I have shown you, and which make good that cause of action, including the nature of the representations they say were made, the matters on which the schemes are said in the pleading to have been promoted, and the fact that it must follow that investors have relied on that. Because if you were told by the way, it's a Ponzi scheme, the 10% is illusory, you wouldn't invest. So it must follow that reliance will be made out. And so my lord is absolutely right, if I'm very respectful, we're in a hypothetical world, but I place myself securely on stepping stones advanced by the claimants themselves, or which necessarily follow as a matter of analysis, given what the claimants have said about Mr. Woodhouse, the way in which the schemes were promoted and the basis on which investors were induced to enter into the schemes. But my lord, one can also do this analysis on the contract measure for the reasons I've given. There is going to be no excess here on a FISMA compensation basis. That is the illusory suggestion. Second analytical point, it's the point we're back to, which is it is wrong to assume that there is an automatic liability under Section 26. It's not just, that point doesn't just apply to Section 26A, it applies, sorry, 26.2a, it applies to Section 26.2b as well. There is no immediate entitlement. So when you are assessing the contrast between the two, that's not a sound starting point. And the third point, and this completely finishes the point off, which is even if we are assessing the matter at that artificial way and assuming in the claimant's favour, even though it's wrong as a matter of law, assuming in their favour that there is an immediate entitlement on day zero or day one, and this is being brought up to compare the position and to suggest there's a deficit. Something more. What compensation could the investor possibly be entitled to for the loss of use of the money on day zero? And that is the way the claimants put this point. If you look at the moment things at a snapshot in time, there's a deficit. At that point, when immediately when the transaction completes, freeze frame, there's a loss because of the compensation. Well, no, the investor at that stage, if we are approaching matters in the world they posit, there is zero loss for having parted with the money, because if you're provided it back in that scintilla of time, there is zero compensation for having parted with the money. My lords, if I may, just 3 closing observations. First of all, no claims in respect of the other heads of loss, so I don't address you on those. Secondly, a couple of observations on the state of the pleadings. We are looking at APOC 5. It is very important to note that there are a number of passages in APOC 5 which were struck out for other reasons, in respect of which there is no appeal. And they were struck out because Sheldon J Mr. Justice Sheldon was satisfied that they were factually immaterial. It's very important that if you turn the pages of the pleading, you have regard to that. The references to the warning notices, the SRA warning notices, are factually immaterial. You must not take those into account. And the references to advice we should have given regarding company accounts, which you'll find at paragraphs 115, 115A and B and 116, are also out of account. I just don't want the court to proceed on the wrong basis. There were also submissions made yesterday about what we knew about the schemes, what we'd done in relation to the schemes and our knowledge of them. I want to make it very clear, again, I can't take you through every page, those allegations are tethered very closely and carefully and rightly to the CIS aspects of the schemes. Our knowledge and involvement is always tethered in the pleading to the CIS aspect. And my lord, allow me to close with this. Properly analysed, the complaint here is that these companies do no longer have investor receipts and that they were not used productively. If they were used productively, my lords, profitable in the long term, as we were entitled to assume, the companies would be in a position to repay, including in respect of compensation. But they no longer have the money and it's not being used productively. That is not within the scope of our duty of care, nor even alleged to be. And the risk which eventuated, it's as set out in the claimant's skeletons twice on this appeal. The risk which eventuated and which caused their current financial position is the fraud of Mr. Woodhouse in those 3 overlapping respects. And that is not alleged to be within the scope of our duty. These are not technical points, they go to the heart of this. And there is no reason to proceed with this case, and Mr. Justice Sheldon was right for the reasons he said. I will done this, I can assist you further.
No, thank you very much. Yes, Mr. Pickering.
My Lords, in reply, if I can start with a brief preliminary point about APOC 5, my learned friend is absolutely right. Mr. Justice Sheldon said that he would have allowed all the amendments bar for a couple of categories of what we would say were relatively minor narrative. For what it's worth, in APOC 6, we had struck those out for obvious reasons. They do remain in APOC 5 because that's the version which was before Mr. Justice Sheldon. But none of those paragraphs are relevant to today. You haven't been referred to them. And so for present purposes, any paragraph within APOC 5 to which the court has been referred, whether by myself or Mr. Saul, does not include the struck out paragraphs.
Do you happen to have at your fingertips either a list of the paragraphs which were struck out or the paragraphs of a judgment which deal with?
My Lord, at my fingertips, no.
No, well, in
But
that case,
one
don't worry.
can see them from APOC 6, and certainly
We can work it.
we can provide them.
We can work it out. Don't worry.
Well,
Yes.
certainly we can provide that information, but I can assure your Lordship that those paragraphs haven't been referred to, and I certainly don't propose to the next 30 minutes or so.
Thank you.
My Lord, I propose to deal with my submissions in reply in 3 parts. First of all, ground 1, no loss. Then ground 3, compensation. And then ground 2, scope of duty, which is probably the most important one. On ground 1, the no loss, the pound in, pound out point, we have 5 points to make in reply. The first is what I call the balance sheet point. It's a short, simple point. The judge's pound in, pound out analysis is, we say, quite obviously wrong, not just as a matter of law, but as a matter of mathematics and common sense. Stanford is of course right. If you receive X pounds and use that to discharge pre-existing liabilities of X pounds, there is no loss. And the way of testing that is to look at the balance sheet position. But, this is the difference, if you receive an investment of X pounds and by that very transaction itself, it involves incurring expense which would not otherwise have been incurred, the pound in, pound out analysis simply doesn't work. The balance sheet at the start of the investment will be X, but at the end of the investment it will be less than X. So it's a very short, simple mathematical point which we say is right in law.
But if the liability to pay the commission arises 1 day later, it's different.
My Lord, it depends whether it is dependent on the transaction itself, the very entering into the transaction. So, for example, an agent's commission, if the investment had not gone ahead, using my Lord Justice Nugee's example, the money is paid to the solicitor in escrow, and then they back out for whatever reason, there's no commission incurred. But the short point is, if £100,000 is paid over, the liability, the Section 26 liability, and I'll come back to that in a second, is £100,000, yet the money received is £85,000 or whatever it is. Well, that's point 1. Point 2 we call the consideration point. In paragraph 110 of the judge's judgment, it's at page 88 of the core bundle, the judge said that the payment of, for example, sales agents' commissions was in respect to something for which the SPVs had received consideration. Lords, yes, obviously that's correct, we don't dispute that. That is simply not the point with respect. The point is that liability only came about as a result of the investment transaction. And it's another way of putting the same point, but the fact that there was consideration doesn't come into it. What is the point is that the balance sheet changes because of that transaction. So the Stanford point simply doesn't arise. My Lord, point 3 on loss is what I call the contingent point. I'm dealing here not with compensation, I'm dealing with the liability under section 26(2)(a) return. My Lord, for present purposes, it doesn't really matter whether the liability is immediate or contingent, whether one has to elect or not, whether our primary submission that it's a default position is right or not. The point is there's a liability or a contingent liability. Either way, position is that there is a contingent liability, so a liability with a contingent or not for, say, £100,000, compared to an actual receipt, a net receipt in practice of less than. So, my lord, I made submissions on this yesterday. I've heard Mr. Saul's submissions. We stand by our primary position that it's a default, but it doesn't really matter. It is not, as my learned friend said, an essential building block of our claim. It may be that the quantification is a slightly more tricky process. That would be a matter for trial, and the courts are well used to dealing with complex matters of quantification. But as to the question of loss or not, it simply doesn't matter whether contingent or not. Well, point 4 on this no loss point, what I call the proportion point or the amount point. We accept this applies only to a proportion of the investment monies received. And my lords, if your lordships would turn to the supplementary bundle at page 509. And I should make it clear that this is an exhibit to Mr. Armstrong's witness statement, which you have not admitted. So I'm not relying as evidence. It's simply it's a simple way of illustrating the point. But I make it clear it's not formally evidence. It's just rather me reading out the figures, which I otherwise could do. One can see the various schemes here, and the sales commissions are £7.3 million, and the legal fees and disbursements are 700, or almost £800,000. So it's about £8.5 million of what we describe these immediately incurred expenses. So does it cover everything? No, but it covers a significant amount. And my lord, we submit these points in themselves. We say it's plain and obvious, and with respect, the judge was completely wrong. He misunderstood the point, and while we accept it only would cover sums, we say £8 million, that's our initial analysis, and that may be argument over that. That in itself, we say, is sufficient reason to allow this appeal and let the matter go forward. So, my lord, those are our points in relation to ground 1, no loss. We say absolutely plain, and that in itself is sufficient to allow the right court to allow the appeal. I move on to ground 3, which is a compensation point. In relation to this, we have 4 points. The first of our 4 points is what I call the fact of compensation point. It's a relatively small point, but it's significant and sufficient for this appeal to be granted. Under the statutory regime, the investors, now creditors, are entitled to their money back, section 26.2a, plus compensation, section 26.2b. What form that compensation takes and to how much it equates is a different matter for another day, we say. There are different ways one can imagine the arguments could be raised, whether it's interest or what the investor creditor would have done with the money. It doesn't matter. It could be a large sum, it could be a small sum. The short point is the mere existence, the mere fact of the right to compensation also makes it clear that the judge's pound in, pound out analysis is wrong. If an investor invests £100,000, he or she is entitled to recover that £100,000 plus something more. And just to respond to my learned friend's point about, well, on day 1 or day 0, whichever, and if it's day 1, there is still this potential liability because it crystallises whenever the claim is made. But to say that there can be no loss, we say it's simply a non sequitur. Point 2, we can make it briefly. It's again the contingent point, same point as above. The compensation we accept. It could be said to be contingent. It's certainly unquantified at this stage. That doesn't mean the claim shouldn't proceed. It involves a loss, and again, the courts are well used to dealing with claims for something which hasn't yet been quantified. My Lord, the pleading point. Your Lordships are familiar with APOC 5. Despite that, perhaps I can take your Lordships to some of the paragraphs once again. Within Supplemental Bundle 160. Paragraph 66, the claimants seek declarations, that's section 26. And we know what has been said about what we say about section 26. But then it says, further, to the extent necessary, the claimants will seek indemnities that arise by operation of section 26. And importantly, page 223, the Lordship should find paragraph 222, 173. We can see it just above that. There is significant section 26 liabilities. And we plead in 173 specific figures. And we refer to them. At 174, they're going to be set out in particulars in Schedule 3. Those are quite clearly section 26 2A losses. Money went in, they're entitled to the money back. That's our case. So 173 sets out clearly what we say, right or wrong, we say it's right, are the section 26 2A losses. But then we go to 177, here's 224. It's a similar language as paragraph 66. Further, the alternative, the claimants seek declarations of schemes of sales operated in breach, and the claimants are liable to investor credit operation section 26. If that means 26 2A, that's in the table. Further, to the extent necessary, the claimants will seek indemnities. Now, my lords, rhetorically, if the 26 2A figures are those in the table at 173, to what else can the indemnity refer? So, my lord, we accept, we take it on the chin. It's not as clear as it could be, and that's why we attempted APOC 6 to make it absolutely crystal clear. But it's there. What else, we ask rhetorically, can the reference to indemnity refer, particularly in the context of the table at 173? If we hadn't put the table at 173, one can imagine an argument that, well, the indemnity could refer to the 26 2A, but it's clear. And also,
what's the purpose of asking for declarations?
A declaration that that the schemes are CIS. So for any adjudication, and that can now enable an investigation into the appropriate compensation.
Well, that would be part of the finding that we've been made by the court in the no matter. Okay, thank you.
Well, yes, we haven't got, for obvious reasons, we haven't got to a case management to whether there'd be some form of split trial and a process of quantification. But my lord, for what it's worth, direct declarations are pleaded. And my lord, on this point, my own friend said, partly correctly, that in the build-up, a lot of matters had been raised in correspondence. There was no discussion at all about compensation in the correspondence. I'll be correct if I'm wrong in relation to that. It wasn't raised. We thought it was sufficiently plain, and it came up during the hearing. But our short position is the investor is entitled to compensation, whatever it is, which we say disproves the or shows to be wrong the judge's pound in, pound out finding, and it is sufficiently, perhaps not ideally, but sufficiently within the pleading. Related to that, going back to the case management exercise, we say to the extent that it was case management, it's a completely wrong exercise of the judge's discretion to dismiss what was otherwise a good, we say strong negligence claim, rather than permitting an amendment to clarify. We do stand by what Mr. O'Doherty said yesterday. we say that APOC 6 spelt it out, but we do maintain it was in there in the first place. And again, my lords, we say the judge was with respect wrong, and again, this point is sufficient, we would invite the court to find, to allow the appeal. My lords, I now move on to ground 3, scope of duty. First of all, I invite the court to look again at the relevant passages within APOC 5, because this is important. But by way of overview, the way that Mr. Saul argues, describes our scope of duty is very narrow, far too narrow. You understand why. He tries to describe it as a very narrow duty. He tries to describe our duty as simply to advise whether it was CIS or not CIS. But quite clearly, on the pleadings, and the material within the pleadings, the scope of duty was far wider than that. My lords, within APOC 5, we invite the court to turn to page 165. I will, for obvious reasons, take this relatively quickly. 83, part of the original text, was to advise in relation to the regulatory, legal and commercial implications arising from the issue of whether or not the schemes are CIS. 85A, in red, it was an express implied term that LF was under duty to advise on matters reasonably incidental to the express duties, namely the regulatory, legal and commercial implications arising from the issue of whether or not the schemes were CIS. And I'll come back to what that means in practice, but the implications, not just the binary advice as this was or was not CIS, but the legal and commercial implications. That's our pleaded case. 173, just for completeness, I invite the courts to look at 90A to C. LS retainer was varied through the course of dealing between LF and the lead companies in the period from April to August 16. The retainer was not limited to set out. And we say that LF assumed a duty to advise on all the regulatory, legal, commercial implications. 90B, we say the course of dealing is evidenced by a number of things. In one, we refer to the close relationship, we say unusually close, inappropriately close relationship between Mr. Woodhouse and Mr. Warner Reed of LF. He's a consultant, his name's on the website. Your Lordships have seen some of the emails where he didn't want advice in writing, it was negative. The regular interaction set out. And then the most important paragraph, possibly, at page 215, under the subheading causation loss, and in 165A, to use the language, to paraphrase the language of Manchester, which I'll come to in a moment, the purpose of LF duties is the following. And out of these are all important, but in particular subparagraphs 5 and 6. So 165A 5, in the light of the advice given, to advise whether, and if so, what changes need to be made to the businesses of NPD and SPVs, including as the promotion and operation of the schemes, and whether the business activities of SPV should be suspended and or the monies should be returned to investors to comply with the relevant legal requirements. 6, to advise what the consequence would be for the NPD and SPVs if they were found to be operating CISs and or did not make the changes and or take the action identified. So the retainer involved not just giving this binary advice, it was the commercial implications, and you've seen reference to the discussions to change the scheme documents. They're involved in the marketing promotion to investors, But we say 5 and 6, this is the purpose. It's to, and I'll come back to manage in a second. It was to protect, not just was it CIS or not CIS, but protect against the implications. 6, to advise what the consequence would be if they didn't make the changes and it was found to be CIS. And Lord, for what it's worth, in the core bundle, page 74, we have the judge's summary of my arguments before him. It's paragraph 39 at page 74. And what the judge said was, paragraph 39, with respect to the claims against LF, the claimants seek to expand the scope of the duties owed to them. The claimants seek to allege as expressed and implied to the retainer that LF was under a duty to advise on matters reasonably innocent of express duties, etc. And then 5 lines from the bottom, in all arguments to Pickering, on behalf of the claimants, explained the reference to commercial implications, reference to the commercial implications of the schemes being found to be CIS. If they were CIS, then the advice should have been the scheme should stop being promoted and no further investment should be taken, as investment of an immediate right to restitution. And I confirmed that we were not arguing, which identified they were Ponzi schemes. My lords, this is very clearly not a normal arm's length relationship. It's not the usual sister-client relationship. And we plead these wide duties. Lord, next point. What is the correct approach? I think we'll agree it's Manchester. The 2 key paragraphs. It's paragraph 6, subparagraphs 2 and 5. I won't take your lordships to that because you've been taken to that a lot. But I would invite the court to go back to page 207 in the bundle, to paragraph 13 of Manchester. And 6.2, as your lordships will be aware, says the question is what the duty is to consider the harm which the advice being sought is to protect. 13 sums it up in the case of professional cases. In our respectful opinion, the scope of duty question can and should be approached in a more straightforward way than suggested by Lord Legate. In our view, the scope of the duty of care assumed by a professional advisor is governed by the purpose of the duty, objective basis, by reference to the reason why the advice is being given and paid for. My Lord, in this case, your lordship, my Lord Nugee yesterday asked me how does it apply in this case, and what I said, I've got it's in the transcript what I precisely said, but the gist, in this case, the retainer was to advise whether or not the CIS, whether or not the schemes were or were not CIS, and the commercial implications. But the purpose, this is the key point, the purpose was to guard against the risks which would arise out of promoting and marketing unauthorised schemes. So this goes back to paragraph 165, 165A 6. That's precisely what we plead. And this is, of course, an appeal from a strikeout summary judgment. The purpose was to guard against the risks which would arise out of promoting and marketing unauthorised schemes. And now if I can come to the nub of our submissions and dealing with Mr. Saul's argument against us, I want to, in the light of that, to say what our case is and what it is not. Because with respect, Mr. Saul has mischaracterised the way we put our case. Our case is this: if the scheme failed for whatever reason, the Section 26 obligation would mean that the SPVs suffer a loss. What we're not suggesting that the collapse of the schemes was due to them being CIS. That's not the point. The point is that if the scheme failed for whatever reason, with a fraud or simple business failure, if they were not CIS, it would, if they were not CIS, it would result in, rather than contractual claims, clear and substantial FISMA liabilities. That's the point. These were schemes that were operating. They were asked to advise, amongst other things, were these CIS or not. If they were CIS and the schemes failed for whatever reason, fair or fraud, fair or foul. And schemes, of course, do fail for good reasons and bad reasons. We say that these SPVs would be materially worse off if it transpired that they were in fact CIS. And my lords, this is important. We repeat, we do not allege the cause of the collapse was due to the schemes being CIS or anything to do with Lupton Fawcett. We do allege that the schemes, having collapsed for whatever reason, the SPV's losses, the deficiency to creditor, is greater than it would have been as a result of the schemes turning out to be CIS, which is of course our pleaded case. Lord, we are all familiar with Lord Hoffman's mountaineer's knee analogy. Could I invite the court to consider a slightly different mountaineer, a slightly different knee? Pose the question a different way. Imagine a mountaineer seeks advice from a doctor. He is aware that there's always a risk of an avalanche. He wants to know that if there is an avalanche, given my knee, will I be able to run away? Now, it's possibly not the best analogy, but your lordship will get the point. And the doctor examines the knee and gives the green light. The mountaineer goes mountaineering, and there is an avalanche. Obviously, that's not within the doctor's scope of duty, that's obvious. But the mountaineer isn't able to run away, and so suffers harm. And using, as Lord Hoffman did, the counterfactual, if the advice had been correct, what would have happened? If the advice, the mountaineer's knee was good, the mountaineer would have been able to run away and avoid the effects of the avalanche. We're not trying to here blame LF for the avalanche. There's always a risk of avalanche. There's always a risk that a scheme will collapse for good reasons or bad. But here, if the scheme did collapse for whatever reason, because LF got its advice wrong, its liability is significantly greater than it would have been if it had not been the CIS. And Lord, here I need to go back to the submissions I made yesterday as to the counterfactual, and in particular deal with Mr. Saul's points which he made a few moments ago. In short, Mr. Saul, his overarching argument was that, in fact, it would make no difference. In fact, he says the contractual and tortious claims would be higher. With respect, he's wrong. The contractual claim first, if there's a coupon of, say, 8%, they're between 8 and 12% usually. After a hypothetical 2 years, the investor would be entitled to, assuming that he or she wasn't paid, 2 lots of £8,000 on an investment of £100,000. As to future payments, there's likely to be some sort of claim, but the first point is there'd be quite a significant discount for accelerated or earlier receipt. Also, these leases, which we haven't examined, this is an appeal from a summary judgment application, they weren't examined hearing below. There are termination provisions, there are option provisions, they haven't explored those. So for my learned friend to say it's a clear-cut case for a contractual remedy which would be the full amount, that's, with respect, ambitious. His tortious claim, we would suggest, is even more problematic. Lord Lees put to Mr. Saul that whereas a Section 26 claim would be, I think Lordship's expression was a slam dunk, claims in deceit are rarely so. Indeed, never so. We know, although Mr. Saul said I said yesterday that we didn't know how much each investor put in. We do. I didn't say that, but we do know. We know exactly how much each creditor put in. What we don't know is whether and to what extent each would have a tortious claim. Each investor and creditor will be in a different position, and there are, of course, thousands of creditors, It depends on the particular representations they received. Issues of reliance may vary from investor to investor, different risk profiles and whatever. The position may vary depending on how early or late in the schemes they invested. Your lordships will, I'd invite your lordships to accept that tortious claims based on deceit, fraud, misrepresentation are far from slam dunks. Well, the short position is Mr. Saul and I disagree. I say the actual FSMA liability is greater, significantly greater, than the contractual and tortious liabilities that otherwise been existed. He says, albeit with respect, without any foundation, that's not the case. My lords, this only reinforces that this is a matter for trial. The defendant should plead to our case, including on scope of duty and on quantification. And no doubt, if your lordships would allow this appeal, there would be expert evidence and, of course, in due course, argument on that expert evidence as to what the true measure would be for FSMA compensation compared to cautious and contract. But Mr. Saul asserts, and in his respect, just assertion, that it would be more, but it is only his assertion, and we say it's pretty plain that's not the case. And my lords, with this, could I remind with respect the court of the caution given by the Supreme Court, the majority in Manchester. It's at page 210. It's within the judgment of the majority, and it starts at the foot, that page of paragraph 26. And I did take your lordships in a canter through this yesterday. Another problem associated with the counterfactual analysis of this kind is the danger of manipulation in arguments of the parameters of the counterfactual world. Lord Legate points out the counterfactual test can yield the right result if properly applied. However, the more one moves in a comparatively straightforward type of situation, as Samco, the greater scope there may be for abstruse and highly debatable arguments to be deployed about how the counterfactual world should be conceived. And in that case, one can see just below B, there was an element of this in the present appeal, as counsel for Grant Thornton argued X, and counsel for the other side argued Y. And then, just above E, Lord Legate engages in a sophisticated analysis to answer the elaborate variance of the submissions advanced by the parties, but the fact is the distinguished constitution of the Court of Appeal fell into error because of them. Again, it seems as the better approach to focus more directly on the purpose. My lords, there's a caution there against, one can I've been making submissions on the counterfactual one way, Mr. Saul the other. I do invite the court to confirm my position, but the short point is it's a matter for it's not always a sound process, in any event a matter for trial. My lord, I am moving towards the end of my submissions. Going back to the judgment, and I do invite the court to look at this, it's at page 89 in the core bundle. The short point is the judge applied the wrong approach. In 112 and 113, the judge refers to Saddington. It's a bit of a red herring. It's obviously the right result, but it's pre-Samco, certainly pre-Manchester. But 114, the same conclusion is reached if one looks at the scope of duty in accordance with the approach described by the majority in Manchester. The duty of care imposed on LF concerned the impact of FSMA if the schemes about which LF was advising and seeking advice from counsel were CIS. If there was a breach of duty by LF, the only harm arising for which there was a sufficient nexus of the duty of care was the requirement to make restitution to investors or a payment to the lenders. That requirement, as already explained, is set off in full by the amount and no loss. So for a start, the judge seems to answer that by, with respect, mixing up the no loss point. But also, the key point is he fell into error. He didn't consider, he uses the language of paragraph 6.2 and 6.5, but doesn't look at the purpose. And the emphasis throughout the majority.
What harm do you say was caused as a result of, for which there was a sufficient nexus to a duty of care other than the Section 26 liabilities?
My lord, it's the Section 26 liabilities.
Yes. Well, and the judges, so I don't think there's any real difference between you and the judge. The only harm arising for which there was a sufficient nexus was the requirement to pay under Section 26. His point is, well, I'm only looking at the restitution of the principal, not at compensation. That's a separate point. If he's right about that, and it is the same point as the no loss point. He's not saying that there wasn't a liability under Section 26, but he's saying insofar as there was a liability under Section 26, it's pound in, pound out. There's no loss. So that's why he tips back into that point. I don't understand you to say that there was any other loss which you seek to recover from these defendants other than the liability to pay under Section 26.
Look, that's correct.
That's correct. Well, then I don't see I don't see this really very much between you on the scope of duty. Anyway,
Yeah.
I think we probably ought to move to wrap it up if you can.
Lord, yes. Very briefly, in terms of the authorities, Empire Jamaica, in that case, the lack of certificate was not the cause of the crash. Obviously, the right decision. But again, here, the purpose was not to guard against the risk of collapse of the business. The purpose was to guard against the risk of the CS implications. Hughes Holland is different. Again, the claim was the loss of the investment. And here, it's the losses which we have suffered as arising out of the CIS advice being wrong. And the final point I would make is, I haven't had time to deal with it, but if one looks at, in particular, paragraphs 34 to 36 of the judgment of the majority in Manchester, they deal with the decision of the particular facts of the case, and they agree with many of the findings of Mr. Justice Tier. They approve it. But Mr. Justice Tier, having found certain matters, then, so the Supreme Court found, reached the wrong conclusion. And we say there's a big analogy with the facts of Manchester and the facts of the present case. In Manchester, Grant Thornton were retained to advise on the accounting treatment. The purpose was to guard against, they were advising whether the treatment could or could not be applied. It wasn't as binary as that. The risk was to guard against the risk of, or help make decisions as to whether to enter into the cash and into the swap investments. And because that advice was wrong, and they did, that was the buying out, the cost of breaking was within the scope of duty. It's very similar to the present case. The advice was, are these CIS or not? Because of the advice which is given, the scheme's carried on. It transpires, as in Manchester case, the advice was wrong. And the implications are, there's a Section 26 liability, both 2A and 2B. The final wrapping up points, it's emphasised in Manchester that while it's a question of law, what the scope of the duty is, how it's applied is a question of fact. Again, this emphasises that one needs to explore, and particularly given our pleading at 165A, 5 and 6, the particular facts. And I repeat, this was not the usual solicitor-client relationship. It was an unusual, less than arm's length relationship. Well, my final point is, as I said yesterday, no defence has been filed. This is an appeal from a strikeout summary judgment, and it's a matter which we say plainly, we can see the arguments which would be raised in a defence, but it's not a case which should have been struck out or on which summary judgment should have been given. So for those reasons, we do invite the court to allow the appeal.
Thank you very much. Thank you both all of you very much for your very helpful and comprehensive submissions. It will be no surprise for you to learn that we will reserve our judgments. We will circulate them in draft in the usual way in due course, which is the opportunity for you to correct our typographical errors and other obvious errors, not to re-argue the case. As you will know, the draft judgment comes with an embargo on it, which means what it says and is to be taken seriously. There will then be an opportunity for you to seek to agree a draft order giving effect to our judgments. If you can't agree, short written submissions you can make, and we will deal with those on paper. I think there's only one other thing I want to say, which is that at least Mr. Pickering, maybe both of you, offered to let us have a note of which paragraphs of APOC 5 stand struck out because the judge would have refused amendments for them in any event. I can see from the judgment that it's those dealing with the warning notices and also the company accounts. But if you could both agree and lodge with my clerk just a list of which paragraphs you agree fall to be treated as no longer in the pleading, that would be very helpful. Is there anything else, Mr. Sell?
I wanted to leave you with one final reference, if I may be so bold, my lord, which goes to the suggestion that it was for us to raise this compensation as the compensation point. It's not in our main skeleton, which is why I want to ensure you have the reference. We deal with it in our supplemental note on the application to amend, and the reference, my lords, is Supplemental Bundle, Volume 2, Tab 23, page 491 of the bundle, paragraph 40. We make the point it's not for us to raise a defence to our strikeout, it's only raised on the final day of the hearing only, and I would suggest that if it was always intended to be included, we would have seen it long before.
Thank you.
Thank you very much, Madam.
All rise if able.